Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book that's come to us from the United States of America for review, and it's an important book on arbitration. The book itself is called International Arbitration, Law and Practice, now in a third edition, and it's been written, and I hope I pronounced the name correctly, Mauro Rubino-Sammartano. I do apologise in advance if I get the names wrong, my misunderstanding of pronunciation. The book publishers are called Jurisnet, and they're based in the United States. My wife and I talked about this book. It's a heavy book. I'll show you it in a moment. Runs to very many pages. We gave it the title in the end, The Study of Arbitration Continues Apace, with Rubino-Sammartano's third edition of this highly regarded and detailed work. And I'll show you the book first, and then we'll talk about what the review is. That's the book. It's a heavy book. It's a hardback spine. There's nothing on the back, effectively. Then if we open it up, let me go to the back first. The back has a very detailed index, which you can see there. And then before the index you have, which is a common practice abroad, not necessarily in England and Wales, but the table of cases is at the back. So you do need to know where to look for the various cases, a lot of tables of cases. There are also, in addition to that, textbooks on arbitration. This is an international publication, of course. Then you have Appendix B, which is articles. In fact, let me just start that. Appendix B is, in fact, other articles. I'm going in reverse order, and Appendix A is the main articles which are directly relevant to arbitration, which you can see there. Then when we get back from that, there are quite a large number of points arising from that, but we then get into the body copy of the book. The appendix starts right towards the end of the book there, you can see, and the back of the book, Chapter 46, there is paragraph numbering, which you can see at the top there, a lot of footnoting, and you can see as we go into the book, you've got quite a lot of subheadings which appear as well, and you do actually have, again, the paragraph numbering and the footnotes, which you can see, which are very, very heavily detailed. Now, the front of the book there is the main front page, and explains who the author, the editor is, and there are forwards by Professor Mayer and Lord Mustill. And there's a nice little dedication there, which I always like to point out. I therefore dedicate this work to all those who unselfishly aspire towards the ideals of arbitration. A nice sentiment, and thank you. This is the summary of the contents, and then there's a lot of them, you can see. It runs through, there are 46 chapters effectively. Then you have the appendices, and then some more detailed contents, which is how this is very much more detailed. Again, that does help because you've got the index at the back and the detailed contents at the front, depending on what you're actually looking for. Then, as I say, you've got the two forwards. The most important one is the most recent one, of course, which is Professor Mayer's forward to the current edition. But in fact, Lord Mustill has produced a very interesting second edition forward, where he talks, the past 2 decades have witnessed a remarkable flowering in the study of arbitration. It's always been a subtle and elusive subject, but until quite recently intellectual problems have been masked by the relatively small scale of the disputes. That has changed, and I think I haven't mentioned it in the review, but that has changed quite dramatically in recent years. Then there's the main preface from the editor, which you have there. Something about the editor himself. It explains who he is, and he's a door tenant of Littleton Chambers in London. And then, of course, you get into the various parts. And can I just point out, lastly, looking at the book, that for each chapter you have a useful little sub-index at the front to try and find things. So it's a nice international structure for books, similar to publications like ones from LexisNexis and so forth. Anyway, let's look at what we've said about Mauro's book. It's a heavy book. The purpose of this lively work of scholarship, says its author, Mauro Rubino-Sammartano, is, quote, to dig into the rich ground of arbitration. It's been published by Juris, as I say, and this volume of over 2,000 pages and 46 chapters cannot be summarised in a few paragraphs, but suffice to say it's an important contribution to the growing body of literature on the complexities of arbitration. And we are in a global community, and therefore international arbitration, as I've indicated earlier by Lord Mustill's statement, shows that we are moving at quite a quick pace towards much more international arbitration dispute resolution, and hence the fact that members of the bar like myself are encouraged to do a lot more on the mediation side, which of course we are doing. There are a number of major problems, of course, which necessitate arbitration in the first place. These, first of all, have to be identified and dealt with, says the author, by the formation of the arbitration agreement and the way in which said arbitration agreement regulates the various relationships that arise from it. Then it's the relationship with state courts, and then finally, but not necessarily conclusively, the available remedies which the parties will be seeking. Basically, the aim of the book is to provide support and or argument aimed at helping readers, professional or otherwise, who are involved in or embroiled in the process of arbitration. And it's now, of course, in a third edition, this book, and it's long established, therefore, and highly regarded, we think, as a work of reference, which deals with a wide range of arbitration issues, including commercial investment, online, state individual, commodities, US-Iran, UN-Citral and sports arbitration, to name but a few. And of course the Iran issue is an important one. The book, we found, is full of interesting examples of the way arbitration works in practice and sometimes doesn't work. Take the case of Strahan and Greece, Strahan versus Greece, which involved a contractual dispute on the part of a refinery that claimed damages against the Greek government. Having lost the dispute, the Greek government then passed a statute that entitled it to repudiate contracts, declaring that the specific arbitral proceeding, as well as the awards rendered, was set aside. That's a member state for you. With wry statement, the author comments that this is an abuse of authority, of which any adjudicator or arbitrator would not approve. The date when this matter took place is not given, although there's a footnoted reference. But you see the longer term implications of it, I'm sure, both in your own member state and within your own particular legal system. Even more noteworthy and historically significant is the example of an international dispute resolved with at least some success, namely the 1981 agreement between the US and the then new Islamic Republic of Iran. When the Shah was deposed in 1979, all commercial and financial relationships between Iran and the US were terminated, with the US taking retaliatory measures, primarily a freeze on Iranian funds. The dramatic climax was the arrest in Tehran of 52 American embassy staff. This was the famous hostage crisis, which after much arbitral intervention contained in the Algiers Declarations, that's the Iran-US Claims Tribunal, it detailed in the book again in very helpful ways. The hostages were eventually released once the US had committed to 4 fundamental obligations. The US only imposed one obligation: the release of the 52 American citizens safe and sound. Agreements between the two countries were eventually signed on the 19th of January 1981, which resolved that crisis. Obviously we are aware of what's going on in 2015 in Iran, but you can see the history and how it has developed. These, of course, are only a couple of examples of the book's insightful, informative and certainly information-rich and quite often startling content, especially in the chapter on obstacles to overcome, which any arbitrator ought to read, in my view. The emphasis throughout is the need for arbitrators to be persons of integrity, aiming at all times for a just outcome and a satisfactory result for the disputatious parties, who invariably always want to win. And that's the problem you've got when you're arbitrating. I'm well aware of it, having done it myself. It is a difficult problem and a balancing act. But the book, I think, is a great friend and help on this, both for the international community. Let me conclude by saying, with its bibliography, almost probably 100 pages, that's for the articles, primary and secondary sources effectively. There's a detailed index which I've indicated, 4 appendices, and the extensive table of awards and of cases, which you find, as I say, at the end, not at the beginning, which is the way we tend to do it in the UK. It's an impressive book which is globally orientated and therefore an important source of research for arbitrators and lawyers, as well as scholars worldwide, and I'm sure they will all find this of great interest and value. It's well known in the US. It should be considered, we think, as an important contribution to the professional libraries of arbitrators everywhere, and the publication of this edition is cited as at 2014. I don't have any specific date, but you will be aware that it's towards the end. There's the book again. It's a very heavy book. The paper's nice. It's not difficult. It's not too thin. Sometimes it can be a bit thin, but the paper's nice. And again, you can see a huge amount of footnoting there, and a lot. If I just point again, not to the cases, there are the awards. The table of awards are there, and then the cases themselves, which are there. But if you go before that, you get to the Appendix A particularly, which is articles on arbitration. And I think, again, this is very much, this book is very much right at the top of the arbitration ladder in terms of the books that you would be interested in. You can see the front page and the subheading dealing with commercial investment online, etc. And then you've got, as I say, a huge amount. Multilateral conventions, for instance, covered there in some detail. That's on the international arbitration law side. And then the arbitration agreement itself. This is the future. This is the sort of thing that we will be doing. We don't want armed conflicts, but we do want to have, we want to be seeing that we have got some systems in place to deal with most of the really big problems that can build up and cause problems. And I do feel that this book is a tremendous contribution to the continuing way in which we deal with some of the very big issues. Obviously, the growth of the online, the new information technology regimes we've got and will continue to get in the next 2 decades of this century, this is where arbitration, I think, will come in a much bigger way. Thank you to all concerned. I think this is a most important publication. Juris are to be congratulated on taking on the publication of it. Thank you to all concerned. It's an excellent book. Bye-bye.